So I want to thank Jessie for her amazing flexibility and willingness to accommodate a Zoom presentation. It's going to be a while before I'm going to get on an airplane again. But Heather Kushnerick and Andrew from Fort Bend can tell you all about that flight. But I do thank Stacy. I think it's a great idea to have kind of a thought-provoking type talk at SWALL, and hopefully I will provoke you to think today. And my comments are based on some comments that I made in January at AALS, and someone foolishly gave me a microphone. And so I made some remarks about which I had numerous comments later. And what I said basically was that it seems like our law libraries are not the crown jewels of the law school anymore. And I mentioned that maybe even our golden age was past. And this is a topic that we've all discussed at different times. We seem to be of one mind that while individual libraries and librarians and even we as a profession are doing some remarkable things, we are collectively feeling as if we were less of our institutions' lives. So my question today is, have we passed the golden age of law libraries? I think that all types of law libraries have a pretty similar history. And while my remarks are mostly about academic law libraries, I think librarians who work in any type of setting will find something to which they can relate. This is a story as much about the practice of law as it is legal education. I apologize if you're bored, but I hope, if nothing else, what I talk about explains a few things to you. Now, I start from a place that says that the reason law libraries exist is to ensure that lawyers and others can conduct legal research. Yes, we do a whole lot of other stuff, but collecting and organizing legal information resources and teaching about them so that we can enable legal research is really our practice. It's our purpose. And we have law libraries to enable legal research. The initial study of law in the US was research. In the 1600s and the 1700s and well into the 1800s, lawyers were trained by reading the law. Any lawyer with a library could supervise students. These students located cases on assigned topics. They analyzed the cases. They identified precedents. They figured out where the case fit in the overall spectrum of the available law, and then they reported back to the lawyer teacher with their findings. Sometimes the students would be asked to compare the law of the UK with the evolving law of Connecticut or New York or Virginia, come up with a table or a chart so we could figure out what the current state of the law was. And sometimes the lawyer teacher would lecture on a subject, whether it be estates of deceased persons or the lex mercatoria or a variety of evidence or pleading or jurisdictional issues. The students would take copious notes, providing themselves with their own handbooks with which to start their own research libraries. As the law grew in scope, the teaching law became more profitable, and law schools became real schools instead of just a room in the lawyer's office. Eventually, law schools affiliated with universities or colleges, but the approach to teaching was similar despite the change in location. The library and research remained central. And this was all taking place in the 1800s, and mostly the late 1800s after the American Civil War. As law schools became the primary venue for legal education in the 1860s and 1870s, there was this simmering tension between the legal academy and the general university. And it can be described in the often voiced opinion that, and I'm quoting, law schools belong in the modern university no more than a school of fencing or dancing. And I'll tell you, this opinion has dogged law schools since that time and is still very clearly evident today. But the sentiment was that the law school was a training program and not an academic course, and that legal education should not even be in a university. It characterized law faculty as little more than glorified tradesmen, teaching students to fill out forms and perform routine pleadings and filings. The rap on law faculty was that they did not engage in the intellectual or creative processes that mark a true university faculty. In order to end this criticism, many law schools began hiring faculty who had little or no practice experience and instead focused in theory in their teaching and scholarship. In large part, law schools that were part of universities decided to be scholarly and intellectual in focus. The rap at the time was that the law faculty did not engage in intellectual or creative processes, so law faculty began hiring new faculty who had little or no practice experience and instead focused only on theory and scholarship. In large part, law schools that were part of universities decided intentionally to be intellectual and scholarly. Faculty developed theoretical interest and wrote articles and books that were similar to those of other university faculty so that they would fit in, justifying the reward of tenure on the same basis as other university faculty. Even as early as the late 1800s, some law faculty were accused of abandoning their primary duties, training new lawyers, for scholarly pursuits. And the practicing bar, those who would come to regulate legal education, protested loudly about the preparation of newly graduated attorneys to actually practice law. In 1878, the American Bar Association was founded in large part for practitioners to have a voice in influencing how students were prepared to become lawyers. Almost immediately, the ABA and its Committee on Legal Education began pushing for all legal education to be conducted in law schools and for those schools to offer the training a young man needed to engage in the practice of law. By 1921, the ABA's first standards for legal education were issued, and now, as the federally recognized accrediting agency for legal education, the ABA still issues those standards. Law schools and their libraries quickly settled into university life, however. It was a good life with high social status and steady employment. Christopher Columbus Langdell, dean of the Harvard Law School from the 1870s to the 1890s, is widely credited with creating legal education as we know it today. He brought to the US the rigorous classroom experience of German universities, refining it into the Socratic methods we still use. He also emphasized individual responsibility and the importance of being able to engage in self-education. Langdell is regularly quoted as saying that the law library is the laboratory for the law, just as the scientists in the university have a laboratory. In the library, students were surrounded by the tools of the law. Through experimenting with various resources and approaches, students learned how to locate the law, just as the scientists learned to conduct experiments in their own library, in their own laboratory. But the library was where students learned to conduct legal research. At the time, the available information resources were manageable. They could be learned through use. There were cases and statutes. There were some treatises and handbooks and dictionaries and the beginnings of indexes and digests, but just the beginnings. And traveling book salesmen were the first legal research teachers. They demonstrated their products and taught law students and faculty how to use them. First among these representatives were those from the West Publishing Company in Minnesota, but representatives from several other companies that no longer exist were also part of the traveling faculty. By the early 20th century, publication of legal information resources in the US was rapidly expanding with the creation of new states, new administrative and governmental agencies, and new publishers with competing products. Finding the law by sitting in the library and experimenting, or with occasional training by publishers' representatives, was no longer an effective way to learn research. More formal training was necessary. So in part because they couldn't rely on the traveling salesman, in part because students couldn't learn the resources of the law anymore by just sitting and experimenting, and in part because of the pressure from practitioners to provide a practical education was growing so strong, law schools added bibliographic instruction into their curricula in the early 1900s. The first permanent teachers of legal bibliography were usually the newest, youngest members of the faculty, or older faculty members who were no longer producing scholarly works. Sometimes they brought in a part-timer from the practicing bar. Simultaneously, law schools recognized that the enormous changes in legal information at the turn of the 20th century meant that they needed someone to manage their growing libraries. They needed a librarian. In the early 1900s, there was a growing number of people who considered themselves law librarians. In almost all law libraries, whether they be academic, firm, court, or otherwise, the norm had been to appoint a clerk or a secretary to manage the library. In law schools, one or more law students might be given the job. Sometimes that junior faculty member or the unproductive faculty member would be moved into the role of law librarian. Soon, however, many of these new law librarians were teaching legal bibliography. Around the time law schools were introducing legal bibliography classes, AALL was founded. Law librarianship began to professionalize, and many of its earliest practitioners were teaching legal bibliography. So we have the move of education into universities, the proliferation of legal information resources, the creation of law librarianship as a profession, and the very beginnings of instruction in legal bibliography. Surely this was a golden age for law librarianship. Well, I think not. I think if we're talking about geological ages, this is the Paleozoic age where we were just crawling out of the ooze. Formal education in librarianship was just getting off the ground. A.J. Small, AALL's first president, didn't even have a high school diploma. But as law librarianship was emerging in the law schools, it was also acquiring what might be its signature responsibility, teaching legal research. It was a great age, an exciting time. Our founders were pioneers and adventurers, but they were not living in a golden age. One issue that arose at this time was that law librarians who were teaching legal research were not typically given the same status as other faculty. Why was this? Well, in the eyes of the law faculty, teaching a skills class hardly merited real faculty status. Skills were not as important as teaching students to think like a lawyer. Real faculty status must be reserved for those who are teaching the intellectual doctrinal classes. Those teachers are the ones who fit in with other university faculty, not some teacher of mere skills. Albert Blaustein, who is an extraordinarily accomplished scholar, as well as the director of the Rutgers Law Library for much of his career, explained it this way, and I quote, "Why don't faculty members and deans consider legal research and writing important? The chief reason is that every law professor styles himself a master of legal research. The worst insult one can give a law teacher is to say he is poor in legal research." Blaustein continued by saying that faculty members, I quote, "won't soil their hands on teaching such an unimportant subject. If they can do it, everyone should be able to do it, and instruction is hardly needed, and status is needed less." That argument from the earliest days of university-based law schools is still heard today and is applied to librarians and clinicians and a host of other faculty. But regardless, of this status dispute, law librarianship flourished as a profession. Librarians earned degrees, and law libraries continued to provide research, instruction, and resources. By the late 1950s, many of the greats whose names we recognize today were shaping the profession. Harry Bittner, Miles Price, Marion Gallagher, William Rolfe, Irvin Pollock, Elizabeth Finley, Joseph L. Andrews. Harry Bittner, in particular, was unrelenting in his emphasis that law librarians have formal educations. His efforts in pushing for library degrees for all law librarians and law degrees for as many as possible shaped the profession in profound ways. In Bittner's mind, having dual-degreed librarians teaching legal research meant that faculty status was both deserved and required. One of the most visible changes he pushed for during this period were the requirements added to the ABA standards that the library director be a member of the tenure track faculty. The AALS membership standards supported this. Most academic law library directors were appointed to tenure track positions during this period. This was the golden age, right? No, I think we've moved to the Mesozoic age, when the giants of librarianship walked the earth. But a new challenge arose, one that threatened our primacy over legal research and kept this from being the golden age. This was the period when legal writing was added to the curriculum. As many of you know, AALS maintains lists of faculty who teach in a particular subject. Teachers of legal bibliography and now legal research have been on the lists since they were first published. In 1947, legal writing made its first appearance on the lists of law teachers by subject. And I think that was the beginning of the end for standalone legal research classes at most law schools. The post-World War II years saw thousands of young men returning to college on the GI Bill. Their lack of writing skills was bemoaned far and wide. Even the most rigid of doctrinal law faculty members agreed that the writing skills of the new law students must be addressed. New classes featuring legal writing were added at numerous law schools. However, like legal bibliography before it, legal writing was considered a training class, not a theoretical or intellectual class. And like legal bibliography before it, the law faculty all fancied themselves great writers. They would not soil their hands on writing any more than they would on legal research. But by the late 1970s, a new kind of faculty emerged, legal writing professionals. They gradually took over legal writing instruction, and today, almost all law schools have at least some full-time, permanent, professional legal writing faculty members. However, the doctrinal faculty were unwilling to reallocate or increase credits in the first-year program. After all, civil procedure is so important and jurisdiction is so critical that we cannot possibly teach it in fewer hours. And the same is true for torts and property and contracts and all the other first-year program classes. But the demand and the necessity for legal writing was undeniable. So instead of changing the curriculum, legal research and legal writing were combined. This was aided by the fact that many felt that research and writing were really not two subjects, but just all part of one big skill. For a while, librarians and writing faculty co-taught this class. Eventually, however, research became a smaller and smaller part of the course. That didn't make research less important. In fact, it was during this period that technology was disrupting our libraries and our law schools and the practice of law. Research was becoming electronic and more complicated in ways that doctrinal faculty trained to research with print indexes and digests did not fully understand. Many writing faculty turned to vendors' representatives to teach what the students needed to learn about Westlaw and Lexis, ironically coming full circle in legal research instruction. And since no one needed books anymore, research was further slimmed down. Ever the survivors. Law librarians started offering advanced legal research classes, bridging the gap programs, one-off legal research classes, and preparing to practice type programs. But for the long-standing requirement of the ABA that the law library director have faculty status, backed up by the ALS membership requirements, we would probably not have any law library director faculty status today. And we would likely have lost any claim to formally teaching legal research. From the 1960s through the 80s and 90s and into the 2000s, we had more of a gilded age than a golden age for law libraries. Construction boomed with new law schools and new buildings for existing schools. Courts and law firms had growth spurts in both physical facilities and staffing. Yes, there were serious ups and downs. The economy did not always support us, but mostly life in the law was good. And criticism from the practicing bar about the preparation for practice heated up again. Starting in 1979 with the Crampton Report, through the 1992 McCrate Report, and most recently the 2007 Carnegie Report and Best Practices for Legal Education, SWALL's intensified for practical education for law students. According to the ABA, students were intellectually prepared to think about the law, but their practice skills were deficient. The American Bar Association responded by making instruction in professional skills mandatory in 2005. Then, in 2014, following extensive deliberations, the ABA took a further step by requiring an increase in the skills training of law students to 6 credit hours, 6 hours of experiential education. The ABA recognized the importance of legal research by including it among the first of the numerous experiential skills it cited in Standard 301B. Recent studies show that on average, new attorneys spend about 30 to 35% of their time researching. A law student needs to graduate from law school prepared to conduct effective legal research. However, about 71% of third-year law students believe they have the research and the practice skills necessary to practice effectively. But only 23% of the attorneys who hire them think this. And this disparity encapsulates the disconnect between academics and practitioners regarding the education of law students. It also illustrates how important it is to the bar for legal research opportunities to be included in experiential education offerings. This brings us to today. And my question is, could we actually be living in the golden age of law libraries? But what would that look like? The golden age would acknowledge the complexity and sophistication of legal research. It would certainly have legal research education offered by law librarians, central to the program of legal education. The golden age would see librarians gain more respect and reap the benefits of that respect. And it would see an emphasis on librarians as key players and service providers, authors, and teachers. What else? What would you add? What would your golden age look like? Take down your thoughts and send them to me. I'd love to hear it. Because I think what we need is a movement. If we can determine what our golden age should look like, how to set in concrete our role in legal research instruction, I think we can look at today, and we'll look back at today, as the golden age of law librarianship. The good news is that many of the key pieces are already in place. We have an extremely skilled and highly educated group of law librarians who are technologically savvy, accomplished in teaching, and creative in responding to needs. We have extraordinary information resources, well managed and organized. We are already recognized as research experts. In addition to problem solving, we can select, evaluate, and use databases and print resources extremely efficiently. We are creating a body of scholarship that solidifies that recognition. There's a growing recognition on the part of the faculty that they need us. They need our help in using legal information resources. We're mostly respected by the faculty. We may not have the status, but we are having the respect. We have continuing support from the ABA, although this seriously needs to be shored up. We have continuing support from the AALS, although this too seriously needs to be shored up. But we are very respected in the larger world of legal education and legal institutions, including with the Uniform Law Commission and the American Law Institute. The library has always been key to legal education. Aspiring attorneys started out reading the law, researching in a law office library. Those libraries moved with the law school into the university setting, quickly becoming the laboratory of the law. Legal research remains the largest academic program in the law school. Mandatory in the first year, required throughout the curriculum. Legal research is the very definition of an experiential course, and it is central to our role as law librarians. We need to get together. We need to put our heads together and figure out how to capitalize on this. Holly Murray, who was a Yale Law grad, a civil rights activist, and Episcopal minister, said, "One person plus one typewriter makes a movement." We have laptops and desktops, which are much better than typewriters. And even though I'm not there, I'd like to start a movement with SWALL right now. It's our choice of if and how to make this the golden age. I say we come up with a plan for ensuring that we have a golden age and that it benefits everyone in the profession. Will you join me in working towards this? I'm so bummed I'm not there to sit down and start this movement right now, but I'd be happy to take questions if you have questions, or to just shut up if you're tired of me.
Questions, anybody? Thank you so much, Barbara.
Thank you, Barbara.
I